Hey guys, welcome back to the channel. So I'm actually making this video 15 to 20 minutes before I leave out for my cruise. And I did not want to leave you all without making another video. So we'll get straight to it because I still have to finish getting myself ready so I can leave on time. So in this video, I'm going to share with you 7 tips. I think it's 7 tips. I may be off a tip or 2, so please forgive me in advance. 7 tips to help you prepare for your closing arguments. Now, the inspiration for this video came from a trial that I recently had where for the first time, I want to say maybe in my career, or maybe it was another time or so, where I actually had time to prepare my closing argument, meaning that I had actual time after the trial was over to leave and then come back. So we didn't present the closings on the same day as the trial. That is rare. But I had time in this particular case. And so I wanted to use that time to really create like a system to help people, or like some tips to help people who are self-represented when they have to give their own closing statement. So with that being said, we're going to get straight to the tips, okay? Tip number 1. So this is after the trial has concluded. So after the plaintiff has put on their case, after the defense have put on their case, and now you get to closing arguments. So tip number 1. Tip number 1, you want to make sure that you address the court. So when it's your turn to give your closing argument, you want to stand up and address the court. Whether you say, Your Honor, we're here today. Well, I'm here today. So I used to saying we're because I'm representing people. But for you, you'll say, Good afternoon, Your Honor, or Good morning, Your Honor. We're here today to resolve the issue as it pertains to the custody of the minor child, or something along those lines, right? But you want to address the court in a respectful way. So that's tip number 1. Tip number 2, begin with a short summary of your theory of the case. So what is your theory of the case, right? So when we go to court, right, there are 2 sides and 2 different stories, 2 different narratives, 2 different theories. What is your theory of the case? Let me give you an example. Let's say you made certain decisions during the breakdown of the marriage where the other side is now trying to use those decisions against you, such as maybe you're trying to move to a different state and that other side is trying to paint you as a monster, a kidnapper, just this evil, malicious person that's trying to take the child away, right? So that's their theory. That's their narrative. What is going to be your theory of the case? What is going to be your narrative? You may say something along the lines of, I had to do the best thing that I knew to do during this time of uncertainty. I've never gone through this before. And so the other side wants to punish me for decisions that were made during a time of a breakdown of a marriage where it's commonly known that there's a lot of uncertainty that comes with that, right? So what is your theory of the case? That's tip number 2. Tip number 3, you want to use the best interest of the child factors or the applicable factors based on the laws in your jurisdiction that are related to your case. So for example, if you're going to court and it's a custody case, you want to use the best interest of the child factors for your jurisdiction to outline your closing argument, right? To use that. And you're gonna understand a little bit more what I'm talking about when I get to the next tip. But you want to make sure it's very critical that you know the factors. So whether it's custody or whether it's a different issue, maybe it's alimony, you need to know the factors. You need to know the law, because that is what the judge is going to use to make a decision, right? It's not a decision that's going to be made based on feelings or based on all these things that you may think is good information for the judge to know, but may not be relevant to the judge's decision. So you need to know the factors, okay? That's tip number 3. Tip number 4, you want to highlight evidence that was omitted and proves each factor that the court must consider to make a final ruling. In other words, show how the applicable law or the factors apply to the facts that you prove through the exhibits and witness testimony. So I'll say that again. So you want to highlight evidence and testimony that proves each factor. So let me give you an example. Say, for example, one of the factors is primary caregiver, right? That's a factor in the state of Maryland. So during your case, did you put on testimony? Did you elicit testimony through a witness that said something along the lines of, maybe you had witness, let's say witness Jane, who testified that I've known the parties for 12 years, and there was a time where I babysat the child, and majority of the time I witnessed mom with the child, right? I witnessed mom feeding the child, clothing the child, and a lot of the times when I was around the parties, I didn't really see the dad do a lot of the caretaking responsibilities. Do you have evidence from a witness? Or you may not have a witness. It may just be your own testimony, but put on some testimony. You want to make sure that there's some testimony that can support the factor of the primary caregiver. So that's what I mean by highlight the evidence that was omitted. So it has to be evidence that was omitted, right? You can't use testimony or exhibits that was not omitted during the trial. So it's very important that you understand that. Moving along to the next tip. The next tip, you want to highlight the evidence that shows how your theory of the case is credible and how the other side's theory is not credible. So what do I mean by that? Maybe you testify that you were the primary caregiver through your own testimony, right? And then you have witness Jane who corroborates what you said, right? And maybe on cross-examination of the opposing party, you were able to catch them in a lie, and they also gave information that shows that you are the primary caregiver. So you want to highlight all of that evidence that shows how your theory of the case is credible and how the other side's theory is not credible. And I just want to add more to that because I realized I wasn't speaking specifically about your theory when I just gave that example about making decisions during a time of uncertainty, right? So maybe you'll have the other side through cross-examination admit that they also acknowledge that there were certain decisions that were made during a time of uncertainty, right? That it wasn't just you who made decisions during a time of uncertainty. They also acknowledge it was a time of uncertainty. Maybe they enrolled a child in a school that you didn't agree with, and you enrolled the child in a school in a different jurisdiction. But then they're trying to argue and make you seem like you're the bad person because you enrolled the child in a school that they didn't like. But they also enrolled the child in a different school during a time of what? Uncertainty. So that's what I mean by that, okay? Moving along to the next tip, okay? Next tip, you want to tell the judge why the other side's is not credible. So it's very, very, very important that you write down, you take notes of instances of a party not testifying credibly, okay? And why do you do that? Because a judge has to make a decision, and the judge has to assess the credibility of the parties, of the witnesses. And a lot of times, as I'm pretty sure you've experienced with a lot of these custody cases, when it's just your word versus the other person, you may know that this person is lying. You know this person is a narcissist and they're lying and they're just charming the court. But how is the judge supposed to know that, right? The judge doesn't know you. The judge doesn't know the other party. And so there are certain things that the judge will look for to assess credibility. And if you are interested in seeing that video, let me know by leaving a comment down below in the comment section and also hitting like on this video. And then I'll make a video just telling you from my perspective what are some things that the judges look for when it comes to assessing credibility. Okay, so again, you want to tell the judge why the other side is not credible. And last but not least, you want to tell the judge one final time the relief that you are asking for and why, right? And so speaking specifically about a custody case, you want to tell the judge a specific relief that you're asking for and why you believe that's in the best interest of the child. So let me give you an example. So you go through your closing, you follow all these tips, and then you get to the end. And you'll say, for example, right? This is an example. And Your Honor, therefore, at this time, I am asking that you grant me primary custody of the minor child. I'm asking that you grant me sole legal custody of the minor child. I'm asking that you award child support pursuant to the child support guidelines. I'm asking that you deny the opposing side's request for attorney's fees based on all the information that was presented and admitted at trial, based on the exhibit, A, that shows that I have all of the records and text messages demonstrating that I was the primary caregiver, and exhibit B that shows that I also incur attorney's fees in this case. And so it's not fair that I also have to pay the attorney's fees of the other side when there is no malicious intent involved with these legal proceedings. So you want to make sure that you let the judge know what you want and why. And when it comes to custody specifically, why you believe that your request is in the best interest of the child. So I believe that's it. I said 7 tips, and I didn't count them. Well, I didn't count them as I was going through them. So hopefully there were 7. Okay. So if this video was helpful, please let me know by hitting the like button. Also, again, comment down below and let me know other, different legal tips that'll be helpful. My disclaimer again, and you'll hear me say this a lot in this channel, I can't give legal advice. I can give legal information. I can't give legal advice, meaning advice that's specific to the facts of your specific situation, okay? Fortunately, I cannot do that. I'm barred by the rules of professional conduct. But I can give you tips to help you prepare for trial, help you organize your evidence, how to present yourself in court, how to control your emotions in court, how to control your emotions during the course of the legal battle, especially going up against a narcissist. So if you're interested in more content like that, again, please let me know by hitting the like button. And until next time, remember, you do not have to walk this journey alone. You have support, you have help. Let me hold your hand and walk with you, okay? Until next time, take care and be blessed. Bye-bye.